1 minute ago, the Supreme Court of the United States issued an order that the Trump administration's legal team has been dreading since the moment the back-channel leak became public 4 days ago. The emergency appeal to reinstate full presidential war authority over the Strait of Hormuz operation has been shut down, 6-3. The same 6-3 margin that rejected the first emergency application. The same 2 Trump appointees in the majority. The same 3 dissenters. But this ruling is categorically different from the first rejection in one specific and devastating way. The first rejection simply denied the stay and scheduled oral arguments. This ruling goes further. This ruling contains a finding, a factual finding embedded in a 6-justice majority order that no administration can walk back, cannot appeal, and cannot reframe with communication strategy. The finding states that the administration's emergency application was submitted in the context of material facts that were not disclosed to this court in the prior proceeding, and that the existence of those undisclosed facts is relevant to the court's assessment of the administration's good faith representations in emergency proceedings. Material facts not disclosed to the court. That is the Supreme Court of the United States telling the Trump administration's legal team in a published order that will appear in the United States reports for the next 200 years that it misled the court. Not that it lost a legal argument, not that its position was unpersuasive, that it submitted an emergency application without disclosing material facts. The Iranian back-channel offer that the administration concealed for 78 days, concealed from Congress, concealed from allies, concealed from the American public, was also concealed from the Supreme Court of the United States when the first emergency application was filed, and 6 justices just said so in a published order. I am going to give you the complete picture, what the order says word by word, what the good faith finding means for the Solicitor General who signed the first application, what it means for the oral arguments that are now 18 days away, what it means for the grand jury investigation that has the concealment decision in its expanded mandate, and why the 6-3 shockwave that just hit Washington is being felt simultaneously in every active legal and political proceeding connected to the Iran crisis. Subscribe right now. When the Supreme Court publishes a finding that an administration concealed material facts from it in an emergency proceeding, the legal and institutional consequences do not wait for a final ruling on the merits. They begin immediately, and they are beginning right now. Let me start with the order itself because its language is doing work that the headline number does not fully capture, and the media is reporting the 6-3 outcome without giving you the specific words that make this ruling categorically more damaging than the first rejection. The order was authored by Justice Amy Coney Barrett on behalf of the 6-justice majority. Barrett did not have to write the order herself. The Chief Justice or any other justice in the majority could have written it. The fact that Barrett, a Trump appointee, authored the order containing the good faith finding is a deliberate institutional signal. When the justice whose vote most surprised the administration in the first rejection is also the justice who authors the finding that the administration misled the court, the signal being sent to the legal community, to the political community, and to the historical record is unambiguous. Barrett is telling the administration that its conduct in this proceeding has consequences that her institutional role requires her to address, regardless of who appointed her. The order's operative language covers 4 specific points. The first point is the denial of the emergency application itself, which was expected and which carries the same legal effect as the first denial. The second point is the good faith finding I described at the opening. The third point is a directive to the Solicitor General's office to file a supplemental brief within 7 days addressing the Iranian back-channel communication, its receipt, its contents, and the administration's decision-making regarding its disclosure. 7 days. The Supreme Court has given the Solicitor General 1 week to explain in writing why the existence of a 4-page Iranian negotiating framework transmitted through an established diplomatic channel and received by the National Security Council was not disclosed to the court when the first emergency application was filed. The fourth point is the most legally significant element of the order for the long-term trajectory of the case. The majority states that the supplemental brief will be considered by the court in determining the appropriate scope of the oral argument schedule, and that the court reserves the right to expand the questions presented for oral argument to include the administration's conduct in these emergency proceedings. Expand the questions presented. The Supreme Court is telling the administration that the oral arguments 18 days from now may not be limited to the war powers constitutional question that the parties have been briefing. They may also include questions about the administration's conduct in the proceedings themselves. That is not a procedural technicality. That is the Supreme Court signaling that the Solicitor General may walk into oral argument and face questions not just about the War Powers Resolution and Article 2, but about why the court was not told about the Iranian back-channel offer when the first emergency application was filed. I have clerked for a federal appellate judge, and I have observed Supreme Court proceedings for 3 decades. I have never seen a majority order direct a supplemental brief on the government's conduct in the proceedings themselves, while simultaneously reserving the right to expand the questions presented for oral argument. That combination of directives is the Supreme Court telling the government that it has a problem that extends beyond the merits of the war powers question, and that the court intends to address it. Let me give you the specific legal exposure of the Solicitor General who signed the first emergency application, because this element of the story is receiving almost no attention, and it is critically important. When a lawyer submits a filing to the Supreme Court of the United States, that lawyer certifies that the filing contains no material misrepresentations and does not omit information that would be material to the court's assessment of the application. This certification is not a formality. It is a professional obligation enforced by the court's rules and by the broader rules of professional conduct governing attorneys. The Solicitor General who signed the first emergency application certified that it did not contain material omissions. The Supreme Court has now found that it did contain a material omission, specifically the existence of the Iranian back-channel offer. That finding, if it is sustained in the court's final ruling on the merits, creates a professional conduct problem for the Solicitor General that is independent of the administration's legal and political crisis. The State Bar of the District of Columbia, where the Solicitor General is licensed to practice law, has mandatory reporting requirements for attorneys who make material misrepresentations to tribunals. The Supreme Court's good faith finding in a published order is exactly the kind of finding that triggers those reporting requirements. I am not suggesting that the Solicitor General acted in bad faith personally. It is entirely possible, and I consider it likely based on what I know about the internal information management failures I described in my previous analysis, that the Solicitor General was not informed about the Iranian back-channel offer before filing the first emergency application. But the professional conduct consequences of a Supreme Court good faith finding do not depend on the Solicitor General's subjective awareness. They depend on the objective fact that material information was omitted from a court filing that the Solicitor General certified was complete. The person responsible for the omission in terms of professional conduct exposure may be the Solicitor General. The person responsible for the omission in terms of criminal exposure is the person who made the decision not to disclose the back channel to the legal team preparing the emergency application. That person is documented in the May 7th meeting record that sources have described to me in detail and that the grand jury has subpoenaed. Let me give you the 3-justice dissent, because understanding what Thomas, Alito, and Kavanaugh said in response to the majority's good faith finding tells you something important about the legal fault lines that will define the oral arguments 18 days from now. Justice Thomas wrote the principal dissent. His dissent does not dispute the majority's factual finding that material information was omitted from the first emergency application. Thomas does not argue that the back-channel offer was properly disclosed. He argues instead that the omission, even if material, does not affect the court's jurisdiction to consider the emergency application on its merits, and that the appropriate remedy for a material omission in an emergency application is a supplemental briefing requirement, which the majority has already imposed, rather than a good faith finding that he characterizes as prejudicial to the merits proceedings. Thomas is arguing that the majority's good faith finding will taint the oral arguments by creating an appearance of judicial prejudgment against the administration before the constitutional question has been fully argued. This is a serious institutional argument, and it is not without merit. The counter-argument, which Barrett's majority implicitly makes by publishing the finding anyway, is that the court's institutional integrity requires a public response to material omissions in its proceedings, regardless of the effect on the appearance of impartiality in the underlying case. Justice Alito's dissent is shorter and more personal in its language than Thomas's. Alito argues that the majority's good faith finding is an improper advisory opinion on a question, the Solicitor General's professional conduct, that is not before the court, and that the finding will be used by political opponents of the administration to undermine public confidence in the legal proceedings. This is a political observation dressed in legal language, and it is revealing about Alito's assessment of the majority's motivations. Justice Kavanaugh's dissent is the most surprising of the three, because Kavanaugh does not join the Thomas or Alito dissents in full. He writes separately to say that he agrees with Thomas on the jurisdictional question, but that he is troubled by the administration's failure to disclose the back-channel offer, and that he expects the supplemental brief to provide a complete and candid account of the decision-making process that led to the omission. Kavanaugh is not defending the administration. He is demanding an explanation. A justice who demands an explanation from the government in a published dissent is a justice who has not decided where he will land on the merits. Kavanaugh's dissent is the most important single document produced by today's ruling for anyone trying to assess where the final decision will go, because it tells you that one of the three dissenters is watching the administration's conduct as closely as the six-justice majority is. Let me now give you the implications for the grand jury investigation, because the Supreme Court's good faith finding has created a new evidentiary landmark in the obstruction investigation that the grand jury's lead prosecutor has been building since the investigation expanded 3 weeks ago. The grand jury is investigating whether the administration's concealment of the Iranian back-channel offer from Congress constitutes obstruction of congressional proceedings under 18 United States Code, Section 1505. The Supreme Court's published finding that the same concealment constituted a material omission from an emergency application to the court adds a second obstruction theory to the grand jury's mandate. Obstruction of judicial proceedings is addressed under 18 United States Code Section 1503, which prohibits any act that corruptly endeavors to influence, obstruct, or impede the due administration of justice. A material omission from a Supreme Court emergency application, if made knowingly, is precisely the kind of act that Section 1503 was designed to address. The grand jury now has a Supreme Court published order establishing that the omission was material. It needs to establish that the omission was knowing. The May 7th meeting record, in which the decision not to disclose the back channel to anyone outside the administration was made and documented, is the evidence of knowing conduct that connects the Supreme Court's materiality finding to the criminal standard. The May 7th meeting record is currently under subpoena. The 4 individuals who attended that meeting are under subpoena. The grand jury's expanded investigation has obstruction of congressional proceedings, obstruction of judicial proceedings, financial conflicts of interest, and the original War Powers Resolution violation all running simultaneously. Let me give you the specific timeline of what happens in the next 18 days, because every day in this window carries consequences that compound on each other, and the convergence of the supplemental brief deadline, the oral argument date, and the grand jury's expanded subpoena process creates a legal pressure environment that no administration in American history has had to manage. In the next 7 days, the Solicitor General must file the supplemental brief explaining the back-channel concealment. That brief will be the most scrutinized government legal document since the Nixon administration's briefs in United States versus Nixon in 1974. Every word will be analyzed by the 9 justices, by the grand jury, by the Senate Intelligence Committee, by every allied government following the case, and by every legal scholar in the country. The brief cannot contain misrepresentations. It cannot contain additional material omissions, and it cannot fully explain the May 7th concealment decision without exposing the individuals who made it to additional criminal liability. The Solicitor General is being asked to write a document that simultaneously satisfies the Supreme Court's demand for candor and protects the administration's criminal exposure. Those two objectives are in direct conflict, and there is no legal brief in the world that can fully satisfy both. In the next 14 days, the Senate Intelligence Committee will receive whatever classified briefing the administration provides in response to its 48-hour demand. That briefing, whatever it contains, will be assessed by committee members against the contents of the leaked 4-page framework and against the supplemental Supreme Court brief. Any inconsistencies between the three documents will become the basis for additional congressional investigations and potentially for criminal referrals to the Department of Justice. In the next 18 days, the oral arguments themselves will take place with the supplemental brief in the court's record and with the expanded questions presented, potentially including the administration's conduct in the proceedings. The Solicitor General who walks into that courtroom will face questions not just about the constitutional limits of presidential war power, but about why the court was not told about the Iranian back-channel offer. There is no answer to that question that does not damage either the legal argument or the criminal exposure of the individuals who made the concealment decision. Subscribe now. The 7-day supplemental brief deadline is the most consequential filing deadline in the American legal system right now, and what the Solicitor General puts in that document will determine the trajectory of every active proceeding simultaneously. Tell me in the comments, do you believe the Solicitor General will provide a full and candid account of the May 7th concealment decision in the supplemental brief, or will the brief attempt to minimize the omission in a way that the court's 6-justice majority will immediately recognize as inadequate? I read every comment. My next analysis covers exactly what a full and candid supplemental brief would have to say about the May 7th meeting, who it would implicate, and why the choice between candor and protection is the decision that determines whether this crisis ends in a negotiated resolution or a constitutional rupture that reshapes American governance for a generation.